Coming on this episode of the program, a conversation with the chairman of the Lagos branch of the Nigerian Bar Association, Bisi Makanjuola. We talk human rights, access to the courts, the process of appointment of judges, and much more. Also showing on the program, two senior legal practitioners share with Law Weekly their views about the task ahead of the judiciary this year, 2024. We also have the weekly recap of the top legal stories in the news. Hello and welcome to the program. I'm Shola Soyele. About a month ago, hundreds of Nigerian lawyers took to the streets to protest against recent incidents of police brutality against lawyers and other citizens. They were led by the chairman of the NBA Securities Agencies Relations Committee, Senior Advocate of Nigeria, Chukwuka Ikwazom, the chairman of the NBA Lagos branch, Bisi Makanjuola, and the chairman of the other NBA branches in Lagos State. Apart from being the chairman of the largest NBA branch, my guest, Bisi Makanjuola, is also a partner in the Tier 1 commercial law firm of Olaniwo Ajayi, where he leads the dispute resolution practice group. With nearly 20 years of experience, Bisi has successfully handled significant litigation and arbitration matters, solidifying his reputation as a leading legal practitioner. I began our interview by asking what demands the lawyers made from the police at the lawyers' protest and the response of the police to each of those demands.
One of the things that we had asked for was that the issues regarding bail being free should continue to remain to be free. The feedback from most lawyers and from most Nigerians is that whenever you find yourself in a police station for a police matter, at the end of the day, when it comes to the issue of you going home, you find that you'll have to pay for bail. And so we made a demand to the Commissioner of Police Lagos State that issues regarding bail being free must continue to remain to be free, because under the laws of the land, bail is free. And that's one key point that we demanded from the Commissioner of Police. One other thing that we demanded from the Commissioner of Police was that the era where lawyers who visit police stations submit their phones at the front desk must stop. We recognize that no lawyer would go to a police formation and take pictures of suspects or record any conversation. And so we don't see any reasons why lawyers should be told to drop their phones at the entrance. We made a demand that must stop, and we draw an analogy that even in the court houses, you are allowed to go with your phone, but you must make sure that your phone is on silent and doesn't disturb the proceedings of the day. So that demand was also made of the Commissioner of Police. One other thing that we requested from the Commissioner of Police was, of course, the issue regarding brutality of police, of Nigerians. So it's not so much about brutality of lawyers, but brutality of human beings, of Lagosians. We still see this incident of young boys who are in dreadlocks, who are carrying laptops, being stopped and being brandished as Yahoo boys or corrupt boys. We demanded from the Commissioner of Police that must stop. And to be honest with the Commissioner of Police, his response was quite, interesting. He assured us that he will look into all our demands, and he also, for the first time, volunteered that he was open to having a joint police and lawyer stakeholder sessions where, regularly, perhaps on a monthly basis, there will be stakeholder engagement between lawyers and police officers. And from what we see, he appears to be a man of integrity, and we know that he will do justice to all of the promises that he made to us.
So what steps have been taken to have that monthly collaboration with the police? This is a new month.
So we've written a letter, to remind him of the promises he made, and we expect any moment from now for the response to come through. Working with the other chairmen of the branches in Lagos State, that letter has gone out, and we expect that the response to our letter should come any moment from now, and then the stakeholder engagement sessions will begin. And we think that it would serve to show Lagosians that this is a brand new Nigerian police, where the interest of Lagosians, of Nigerians, is at the top priority for the Nigerian police officers.
One of the incidents that led to that protest was the assault of that young lawyer, Olumide Shonupe, who was assaulted at the Gowon State Police Station. Now, we heard that the police officer who assaulted him has been redeployed, but is that really enough punishment, or is there something else about the punishment that is not in the public domain that we don't know?
Certainly not. When the Commissioner of Police attended our meeting, he informed us that that officer had been redeployed. But as far as we're concerned, we don't want a redeployment. We want a removal. because what is the guarantee that the man will not be posted to another police formation? What's the guarantee that he will not do the same thing? Because from the information we gathered from our colleague who was there, the man had boasted that nothing will happen to him. And we want to follow through with the Commissioner of Police to make sure that indeed this officer who was removed from Gowon State Police Division does not find his way into another division where, of course, he then begins to do the same things that he was doing whilst he was at the Gowon State Police Division.
I know that there are 5 branches of the NBA, and the NBA Lagos is the largest branch of the Nigerian Bar Association. He has over 10,000 lawyers? 13,000. Now, as the chairman of the largest branch, can you let us into other ways that the branch is addressing issues that concerns Nigerians? I mean, let's talk about police brutality is a human rights issue. I know that the branch has a human rights desk. So is that limited to addressing issues of lawyers, or can members of the public just walk in to assess the services of that desk?
We have a dedicated human rights desk. There's a dedicated email address and phone number, and I'll share both with you before the end of the interview. What we're doing is to sensitize Lagosians to say that anybody whose rights is being trampled upon can reach us on our phone number or reach out to us on our email address. Just send to us the particulars of whatever it is that is the issue, and the NBA Lagos will be quick to swing into action. We have a dedicated human rights desk. Our human rights lead, who incidentally is the vice chairman of the branch, is doing fantastically well in that field, Esther Ifeanyi. She has a fantastic committee members that she's working with, and that committee has been doing so well in the areas of human rights. From time to time, they go to prisons, they go to police stations, to help to decongest those places. They also go to different security agencies in the country. So they were at Matiyaba the other day, just to have a synergy with these security agencies, to find out the problems they're facing, and also find out the areas in which they expect the bar to assist them. But generally, for members of the public, whether or not you're a lawyer, if your right is trampled upon, please reach out to the NBA email address, reach out to the NBA Lagos hotline, and we'll be quick to jump to your defense. Be it domestic violence, be it human rights abuse, be it child abuse, whatever it is, reach out to the NBA Lagos, and we'll be quick to swing into action.
In your manifesto and before you came into office, one of the things that you said you do something about is court reporting, court monitoring and reporting, and also elevating the standard of law practice. What progress would you say you've recorded in that regard?
So let me start with the court monitoring. What we are doing, and we're doing this in conjunction with the Judiciary Relations Committee of the branch and the Justice Reform Sector, is to collate the data on the sittings of judges, particularly in Lagos State. So we want to use the Lagos State High Court as a case study, collate the data on the sittings of judges, and every Friday to then publish the data that we have. So for instance, the data would have that Justice Y sat at 9 o'clock, took 10 cases, Justice B sat at 10 o'clock, took 2 cases, Justice C sat at 11 o'clock, took 4 cases. That data, when published, it helps the entire public to have a view on the performance of the judiciary. It also helps the judges in terms of their own compilation and record keeping of their performance. So that way it helps both parties, whether the bench or the bar. It helps them to know what is happening regarding the justice delivery sector in Nigeria. And one other thing that we're doing, which is very key to us, is that we want to use Lagos as a standard for other branches to follow. I tell people that I can only sell legal services. And so in selling my legal services, I must do the best that I can to make it attractive to everybody. And so we want to use Lagos as a case study where we elevate the standards of practice in Lagos. So we're starting with the courts, and then we face ourselves as lawyers. We are training our lawyers to be self-oriented, to make sure that, look, the cases, the reasons why the courts are congested today is because many cases that are frivolous find their way to the court system. But when you educate our lawyers and a client meets you to probably instruct you on a case that is albeit frivolous, because of the training that the Lagos branch of the NBA has given to you, you are in a position to tell your client that I cannot take up this case because this case will not be in the interest of justice. That is one of the ways in which we're trying to give back to train our members, to then reduce the courts, dockets, and at the end of the day, you find that the judges would only have serious cases to deal with. And one other key thing that we're doing is come sometime this year, between the 3rd and 4th month of this year, we intend to send some of our deserving lawyers on a secondment, fully paid by the NBA Lagos, on a secondment to the UK. We've concluded plans with the top UK law firm, and any moment from now, we'll set out the machinery towards choosing the successful, lawyers that will go on secondment to the UK. The only condition is that they come back to Nigeria. We don't expect that they will jackpot, for instance. So we know that because we are responsible people, and so we know that the lawyers who are deserving and who merit this secondment will come back. They would learn from the way things are done in the UK, and they can then bring the experiences back to Nigeria, and then to see how we can learn from all of those things.
So you've talked about the performance of the judges and justice delivery and elevating the standard of legal practice. And I'm looking at the quality of appointments of judges to the bench. How does the branch get involved in this? And do they even take feedback from the branches?
Well, they ought to take feedback from the branches. And I'm being careful with my choice of words now. They ought to take feedback from the branches. But even before you ask for the feedback from the branches, what is the selection process? The persons that have been earmarked to become judges, how did you arrive at them? What is their antecedents? What is their legacy? What have they done? The era where we make wives of judges, children of judges, friends of judges, I think it must stop with due respect to the powers that be. We should only focus on persons who merit it, not because they belong in the system, but because they deserve to be judges. And so at the Lagos branch, one of the things we look at when we hear that certain persons have been earmarked to become judges is to call for their CVs, to review their CVs. And then once we've reviewed their CVs, we then reach out to our members to say, oh, X, Y, and Z have been shortlisted for judges. Do you have any reasons why they should not be judges? And you'll be surprised at the kind of feedback we've gotten. Recently, we had a feedback, for instance, that said, oh, somebody should not be a judge because that person in a civil case made an order for his client to be committed to prison. And we ask ourselves, give us the particulars, give us the record of proceedings so that we can test what you've said to us. And the lawyer went quiet. You'd have expected that lawyer would be bold enough to come out. And you'd have expected, for instance, that lawyer would give you the record of proceedings to verify the point he's made. But we never saw any of those things. And so we had no choice but to just give a clean bill of health.
I want to round up with the issue of access to the courts and ultimately access to justice. A lot of lawyers have had complaints about the e-filing process of the Lagos State Judiciary. I know that I've attended some of the bar bench forums also on that issue. But what's the situation now? Have things improved, and how is the branch helping to make that seamless? Yes,
the e-filing system in Lagos I think it's getting better. About a month or two ago, we had a training where we collaborated with the Ikeja branch and had a training on e-filing in Lagos State. That training was done on Zoom and it was well received. We had over 1,000 players participate in that training. Those are the things that we can do. We can continue to train, continue to create opportunities for players to learn how to do these things, because we learn every day. So that's on access to the courts. Well, access to justice is something different entirely, and I think it's another conversation that we cannot finish today. But for me, the access to justice starts from we as lawyers. What are the nature of cases that we file in courts? I've always advocated that we need to find a way to review the Constitution to take away the automatic right of access to the courts, because I feel that because there is no bar on the kind of cases that are filed in courts, it inhibits the ability of judges to dispense with justice. And what do I mean by that? I can go to the court and file a case and ask the court to declare that Shola Soyele, you are a man. And I will pay filing fee to the state government and they will accept my case.
They will accept that case?
Yes. As a matter of fact, if I ask for ₦1 million in damages, I will be assessed based on the amount I put on paper, not based on the merit of my paper. And so we are saying that all of that must stop. Let us work towards filing cases that have got merit. Let there be a filter that can look at cases on the face of it to say, oh, this case does not have any merit, we shall not accept it for filing. But of course, nobody has the power to do that until the constitution is amended. But talking about that, even when you file your case and then you lose, you can't go to court automatically, i.e. the appeal court automatically. We must also find a way to limit your ability to automatically run to court of appeal. Because again, in Nigeria, you have an automatic right of appeal from the High Court to the Court of Appeal. And so everybody goes. So you find that in a purely civil commercial transaction that should take at the minimum a year to resolve, you find litigants spend 10 years on a purely commercial transaction. Where is the justice when you go to court and come back after 10 years? Where is the justice? I'm not saying that all of these cases have no merit, but I'm saying that when we are briefed, let us make sure that the cases we take to courts are, cases that have merit, so that we do not clog the wheels of justice, because a judge is as good as the arguments you put before him. If a judge has 40 cases to do in a day, he will focus his energy on 40 cases. But imagine if a judge has just 10 cases to do in a day. Then you get the best from that judge, because he has more time to deal with just a few cases, and perhaps those cases have merit. So let's hope that we get here, but it all starts from the amendment of the Constitution.
Thanks for staying tuned. Next, we bring you the views of two senior advocates on some of the challenges confronting the judiciary and what stakeholders and government can do better this year.
The 2024, we are here, God sparing our life. It's no longer election year, except some of those few election matters from the states. My view is that, for example, the Supreme Court, now we have, God helping us to have a full court, quorum. There should be discongestions. What I mean is that there will be more hands now. So the decisions, the durations of hearing appeals will now be reduced. Instead of looking at the Supreme Court, any matter across the Supreme Court, you cannot talk about less than 6 or 7 years before you get right for hearing. So let us do some weeding, some, call it exercises that may be, whether it's criminal or civil clearance, to deal with this, so that we can make way for speedy and expeditious dispensation of justice as the cases come. So those are those cases from the Supreme Court. Say this go for the Court of Appeal and all the courts. The essence is that when justice is denied, the efficacy becomes meaningless. It becomes pyrrhic. And don't forget, particularly in civil matters where you have now, our naira is dwindling. You're asking for debt. You're asking for some recovery. At the end of the day, the monetary value of what you're asking for, you can't compare it with the previous time when this matter started. So my view is that the dynamic nature of economically, the judiciary should come in headlong to also assist, so that that justice will be even a balance economically alongside with quick disposition of matters. That's the simple agenda, and all stakeholders must be on deck here, whether it's the legal practitioner or the judges or the criminal aspect, all the security agencies, the EFCC, the ICPC, the police, the SSS, the NDLA. All hands must be on deck so that we can make progress. The society is dynamic. As we grow and we improve and we increase, there are bound to be more frictions. There are bound to be increase in crime. There are bound to be more in civil matters and frictions. So there have to be a procedure where we must adjust and adapt and anticipate this. Otherwise, we will be at the running end, at the backstage at all times.
Our judicial officers are not being well paid. Although I'm aware this current government is doing something about that, for which we have to commend them. most especially the President and the Attorney General. We have to commend them for looking into the poor remuneration of the judges. And when I say judges, not just the Supreme Court justices. I'm talking of the Court of Appeal judges, High Court judges, National Industrial Court, Federal High Court, all of them. The pay is bad, very bad. Perhaps I should also mention the fact that the highest court of the land, the jurisdiction, should be revisited. Not all cases should end up in the highest court of the land. I do not think the highest court of the land is meant to be taking all manners of appeals. Some appeals should die at the Court of Appeal. At worst, all appeals to the Supreme Court should be with the leave of the Supreme Court, and not a situation where everybody, all manners of appeal, will now end up there, and then the docket is always full. Then people are struggling for dates, and in the process, all sorts of untoward attitude, untoward actions by some staff of the court and what have you. So I believe there is a need to streamline the jurisdiction of the Supreme Court in a way that it is not all appeals that will be allowed to go there. So motions should be a matter for chambers. Substantive appeal should be a matter for open court. That is my humble opinion.
And just before we go, a quick recap of some of the top legal stories in the news.
We begin with the report that the Supreme Court has affirmed the election of Governor Ahmadu Fintiri of Adamawa State. The 5-member panel of the Apex Court, headed by Justice John Okoro, unanimously dismissed the appeal by the candidate of the All Progressives Congress in the last governorship election in the state, Ms. Aishatu Dahiru, for grossly lacking in merit. The court held that the initial declaration of Ms. Dahiru as the winner of the election by the state's resident electoral commissioner was unlawful and a nullity. At the Federal High Court, Abuja, Justice Iyang Eko has adjourned a suit by the leader of the indigenous people of Biafra, Nnamdi Kanu, against the federal government to February 8, 2024. In the suit, Kanu accused the federal government of kidnapping him from Kenya and bringing him to Nigeria for trial. He also wants an order for his release from the Department of State's custody. Kanu asked the court to order the federal government to pay him 50 billion naira as damages. In a preliminary objection filed by the federal government and the AGF, they described the suit as an abuse of the court process, urging the court to dismiss its process. The defendants held that Kanu filed an earlier suit with similar facts before a federal high court in Umuahia. At the Federal Capital Territory High Court, Abuja, the trial of the former Accountant General of the Federation, Ahmed Idris, on an alleged 109 billion naira corruption charge has been adjourned to March 20, following completion of the cross-examination of the first prosecution witness. Mr. Idris is being tried alongside 3 others by the EFCC for the alleged diversion of the money. During the proceedings, the witness admitted that the former Accountant General did not have a lawyer with him when his statements were taken during investigation by the anti-graft agency EFCC. The witness informed the court that the anti-graft agency took the statements of the former Accountant General 6 times in the year 2022, and on all of these days, he waived his right to an attorney as a condition to being granted bail on self-recognition. The trial judge, Yusuf Halilu, admitted as evidence a video tendered by the EFCC, which contains an interview session of Mr. Idris and 2 other accused persons, a recording done with the use of a smartphone without their knowledge. The EFCC will call its second witness in the continuation of the former Accountant General's trial on March 20. And we round up with the report. The senior advocate of Nigeria, Femi Falana, and an early childhood education specialist, Hawa Mustafa, have sued the federal government, the Minister of Education, and the Universal Basic Education Commission over their failure to access 68 billion naira Universal Basic Education Commission funds to provide free basic education for every Nigerian child of school age. The Attorneys General of the 36 states of the Federation and Minister of the Federal Capital Territory, Abuja, were also listed as respondents in the suit, which was filed through their lawyer, Senior Advocate of Nigeria, Mrs. Fumi Falana. In the suit, which was filed on January 19, the applicants asked the court to determine, amongst other things, whether the respondents are not under a legal obligation to provide free, compulsory and universal basic education for every Nigerian child of school age by virtue of Section 2, Subsection 1 of the Compulsory Free Universal Basic Education Act of 2004.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I am Shola Soyele. Thank you for watching, and see you next week.